what I want to do over the next few days is basically give you all some kind of introduction into the governance structure of Trinidad and Tobago, because I think as parents and as advocates, you kind of have to know the system that you're working with. So today we're going to focus more on the Constitution, which is basically what sets out how our government works and what it can and cannot do. So first we're going to look at the Constitution, and coming out of that, we're going to look at the three different arms of the state to kind of get an idea of who is responsible for what. And I think that it's a lot of information, right? Because I could teach a lecture on just one subtopic of what we're going to cover. So I've tried to condense things as much as I can, but I think it's important for you all to have this kind of foundational knowledge, because you have to know how the system works and what we currently have in place for persons with disabilities if you are going to be an effective advocate, right? And then what I'm going to do tomorrow is kind of drill down more into disability as a human rights issue. So is it a human rights issue? What does that mean? What is the impact of the CRPD, which I'm sure all of you all know about and probably wonder, well, how come the CRPD has so many provisions in it, but when I look at what is available in Trinidad and Tobago, there's a little bit of a disconnect. So we're going to explain that, and I'm also going to try to highlight some of the things that you all can focus on as advocates in relation to legislation in Trinidad and Tobago, and how you could actually use some of the pieces of legislation that we do have on the books, like the Equal Opportunity Act and the Freedom of Information Act, how you could use those two pieces of legislation as advocacy tools. So that's what we'll do tomorrow. So today we're going to focus on the Constitution and the three different arms of the state. So the first topic, obviously, is the Constitution. And the reason why I want to start there is because constitutional law is a topic that all of us engage in, whether we know it or not. So a lot of the issues that we talk about in our homes, or a lot of the things that we see on the news, for example, if you looked at the front page of the Express today, which is talking about the Chief Justice trying to take action against the Law Association, that's a constitutional law issue. So if you think back to things like Section 34 or the President's housing allowance, if you think about the debate that we're having right now about the passage of the Anti-Gang Act, all of those things are constitutional law issues that we all talk about, and it generates a lot of debates, but we probably don't even realize that what we're talking about is debating issues that deal with the highest form of law that we have in Trinidad and Tobago, which is what the Constitution is, right? So, and that's not something that's unique to Trinidad and Tobago. All throughout the Caribbean, we have these written constitutions, and the reason why you have to start with the Constitution if you want to understand anything about the state or about the government is because the Constitution is the supreme law of Trinidad and Tobago. So that's why Professor Carnegie, who is a very famous constitutional law scholar, he's deceased now, but if you do any reading about Caribbean constitutional law, you will come across his name. And what he described constitutional law as is the place where law and the government kind of meet. And if you were to think about what a constitution does, or what it is supposed to do, and what our constitution does, you'll understand why what Professor Carnegie says is true. Because one of the things that, or I guess the primary thing that a constitution does is that it establishes all of the different institutions of the government. So it will tell you that there is a president, there's a prime minister, there is a leader of the opposition, there's a chief justice, there's a judiciary, there's a legislature, and it tells you who those people are. It tells you what are the qualifications to become the president or to become the prime minister. And then it tells you what they do, and it also tells you what they are not allowed to do. So basically, the Constitution is kind of like the roadmap if you want to understand the inner workings of the government or the state of Trinidad and Tobago. Another important thing that it does is that it tries to balance the rights of citizens or individuals against the state. So anytime you have a state structure, especially the ones that we have in the Commonwealth Caribbean, which gives the state and the Prime Minister a lot of power, one of the things that you always have to do is determine how am I going to keep that power in check? How am I going to ensure that this system of government remains democratic and it's not going to end up in a dictatorship? A constitution helps you do that because what it does is spell out the rights that all of our citizens have. And when we come to talk about the Bill of Rights, you all will be able to tell me, well, what do you all think about the rights that we have in our constitution? And from the perspective of disability, do you think that the rights that we have there are enough? Or should we have rights that are specifically tailored to protect persons with disabilities and to provide for their needs? So another thing that the Constitution does is that it kind of tells you, it gives you an idea about the kind of society that you're dealing with. Because the first thing that you will see when you open it up is called a preamble. And what that preamble does is kind of tells you what are the values that Trinidad and Tobago holds there. And if you look at that preamble, you will probably be kind of surprised, because one of the things that it talks about a lot is that the resources of the country has to be used for the benefit of everyone, right? And that we are a society that believes in equality. We are a society that believes in providing for everybody. And I'm sure as parents of children with disabilities, that sounds strange to you because you're living in this society, but there is a disconnect between what this law, which is the supreme law of the country, says and what is your lived reality, right? And then the next thing that the Constitution does, which is also important, is that it kind of identifies what is Trinidad and Tobago. So remember, we are islands, right? And there are a lot of natural resources in our oceans. So it sets out what are the boundaries, where does Trinidad and Tobago begin and end. And obviously those things are very important to protect other states from encroaching on our natural resources. And it also tells you how you could become a citizen, or who is to be considered a citizen of Trinidad and Tobago. And that is becoming very, very important because of what is going on in Venezuela and the influx of immigrants that we have. So the Constitution actually gives you kind of the path to citizenship. Yeah? Does anybody have any questions? And if anybody has any questions at any time, you could just put your hand up and let me know, because I tend to, it's easy for me to kind of go on and on and on, because this is an area of law that I really like. Yeah? So now that we know kind of why we have a constitution and what it means to us and what is the function of that document, we could kind of get into the structure. So the constitution is pretty long, right? And that kind of, it's kind of obvious why it has to be so, because of all of these important functions that it plays. But if you look at it by chapter, it makes it easier for you to understand it, and it also makes it easier for you to go it through, because if you're really not that interested in the Integrity Commission, you could just skip out chapter 10, right? Or if you're not interested in learning about the Parliament, you could skip out chapter 4. If what you really want to learn about are what are the constitutional rights of your children, you should probably go to chapter 1, right? And what I've tried to do with the chart there is kind of break up those chapters into those 6 areas. So the first thing that you have in the Constitution is the preamble, which I told you sets out kind of the value system that we have in Trinidad and Tobago. It sounds very nice. The problem with it, and I think the reason why it sounds so good and we have been so generous with the language that we use there, is that the preamble is the only part of the Constitution that is not enforceable. So even though it says we have all of these natural resources and we are supposed to follow an economic structure where those resources would be used to benefit everyone, we all know that that is not happening. Maybe in the beginning when we first became independent, it happened a little bit, but over time it's not happening. And the problem is that we can't now go and say, okay, I'm going to sue the government for breaching the Constitution, because the provision that we're relying on is in the preamble, which is not enforceable, right? The next set of sections that you will see in the Constitution is called the Bill of Rights, which is, I think, very important for parents or even for persons with disabilities to know what their rights are. And I'll go into that in a little bit more detail, because I really, really think that that is probably one of the most important pieces of information that I want you all to come away with. And the next thing that you will see is something called a savings law clause, which I'm going to explain a little bit later on as well. As I said before, it tells you how you become a citizen. It also tells you what are the different arms of government. So from chapter 3 till about chapter 7, so chapter 3, chapter 4, chapter 5, and chapter 7, that's where you get a lot of information about the state, which we have divided into 3 different arms, and who makes up each one of those arms, and what they can do and what they can't do, and how they actually become those different office holders that are mentioned in those sections. And then the last thing that we have in the Constitution is provisions for a lot of institutions to be independent. And again, that's because one of the things that a Constitution is supposed to do is protect the minority from the majority, or to protect persons with a lot of power from running amok. And one of the ways that we do that is not just giving persons rights, but also setting up a lot of institutions which are going to function independently of the state structure. And a lot of them are supposed to, even though we know that probably does not happen as often as it should, it's supposed to keep the state in check, or keep an eye on what the state is doing. But again, we have a little bit of disconnect between what is written on the paper and what is our lived reality in Trinidad and Tobago, yeah? So now that we kind of went through the structure, whenever you're reading the provisions of the Constitution, these are kind of the foundational principles that you have to have in mind. Not all of them are going to actually be in the Constitution. So for example, if you were to do Control F and you put in the word entrenchment, you probably won't find it. But entrenchment basically is a way that we make sure that the Constitution is not easy to change. We don't want it to be too easy to change the provisions that we have in there, because they are so fundamental to the way that we govern and the way that we live in Trinidad and Tobago, right? If you do Control F and you look for the Supreme Law Clause, you will find it. And it's actually pretty high up. It's the 2nd section of the Constitution. And basically what it says, if you didn't know before, is that the Constitution is the supreme law of Trinidad and Tobago. And if you have another law that is inconsistent with that Constitution, that inconsistent law is void. And when we say something is void in law, that means it has absolutely no effect whatsoever, right? Because the Constitution is supreme, there are certain things that flow from that. So one of the things that flow from it is that the state has to comply with the provisions of the Constitution. They don't have a choice. So there is something called mandatory compliance, which means that whatever the state does, it has to ensure that it is doing it in the way that is provided for in the Constitution. Because we have that mandatory compliance, it also means that the power of the state is limited. Because if the Constitution says that the government cannot do something, which it does, right? Section 5 of the Constitution spells out all of these different rights that cannot be taken away by any law. So whenever the government tries to pass legislation, one of the first things that attorneys do if they are reviewing that bill is to go to Section 5 to see, listen, this piece of legislation that you all want to pass, is it going to impact on any of the rights that are provided for in Section 5? And if it does, you can't pass that act unless you go through certain procedures, and even then, it might be near impossible for you to do so, so you should probably not bother. Yeah? Right, so law is all about learning the general rule and then all of the hundreds of exceptions to it. And I think that's why people don't like lawyers. Because we will tell you, well, this is the rule, and then when you try to apply the rule, we'll tell you, no, the rule doesn't apply that way because there is this exception. So what I've just told you about the Supreme Law Clause, that is like a general rule. The Savings Law Clause is the exception to that. So, and it's difficult to kind of wrap your head around. I don't think there are a lot of attorneys, and myself included, who up to now I can't understand it. Because what the Savings Law Clause does is that it saves all of the laws that were on our statute books when we became independent. So some of the laws that we have from colonial times, if you match them up against the Constitution, they will not be compliant. The perfect example is the death penalty. We have a Constitution that says you cannot subject a citizen to cruel and unusual punishment. And we have all of these cases from all over the world that tell us that if you put persons to death by hanging, that is subjecting them to cruel and unusual punishment. Yet, Trinidad and Tobago still has the death penalty. The reason for that is because the death penalty and the law that creates it is saved. So that even though those laws don't comply with the Constitution, we can't say that they are unconstitutional. What we have to do now is pass a new law abolishing that old law. Everybody follows that? Yeah? Okay. So good. I'm a little bit better at explaining it than I thought I was. Right? And then that's why we have Professor Simeon McIntosh, who again is a very famous Caribbean constitutional scholar, saying that, listen, these savings law clauses don't make any sense, because it's almost like I am coming to Teresina and I'm giving her this pen and then I'm taking it back. Right? So the Constitution is giving you all of these rights, and then it's slowly taking everything back by allowing these laws, which we know are unconstitutional, to still stand and be valid, right? Even though the Supreme Law Clause says if you have a law that is unconstitutional, the law is void. The Savings Law Clause is kind of like an exception to the Supreme Law Clause. The Entrenchment Clause and the Supreme Law Clause work hand in hand with each other. So what entrenchment is, it's actually a legal term. And what it means is that the provisions of the Constitution are not easy to change. If you want to change a provision in the Constitution, you have to go through a particular process. And again, this is not something that is unique to Trinidad and Tobago. All Caribbean constitutions have them. The only thing that is not unique is probably the Savings Law Clause. So Belize, because they became independent in 1980, they were smarter than us. So they put an expiration date on the Savings Law Clause. Right? So they said, okay, I'm going to keep all of these British laws for 6 years. After 6 years, 1986, you can't tell me what to do anymore. By then I should have grown up and matured enough to be able to govern myself, right? But all of the Caribbean constitutions have entrenchment devices. So for example, if you are following the debate about making the CCJ our final court of appeal, to replace the Privy Council. The reason why we can't do that is because the provisions in our Constitution dealing with the Privy Council are entrenched. It's not easy to change it, so it's not easy for us to make that switch. That's why the government needs the support of the opposition, and they need those votes, because that particular provision in the Constitution, in order to change it, you have to have a special majority. And it is highly unlikely, unless we go back to like the days of the NAR with 33-3, that any modern government is going to have that special majority by itself, right? So what I did there is kind of spell out all of the different entrenchment devices. So the one that we have in Trinidad and Tobago is a special majority. We also have recitals. So basically what recitals do is that sometimes you will open up an act and you will see that this act is supposed to have effect even though it is inconsistent with section 4 and 5 of the Constitution. That's a recital. And the reason why recitals are an entrenchment device is because when you are sitting down in the Parliament or when you are drafting that legislation, if you see that from the opening, you will read that piece of legislation a little bit more carefully, because it will be giving you notice that the provisions in the legislation are intended to affect what is in the Constitution. So basically a recital is just words saying this act is going to affect the provisions in the Constitution. And it's words that you use in the beginning of the particular piece of legislation. We also have certificates. So because we have special majorities, we need someone who's good at math, right? Which I am not. I think most lawyers are not. So we need someone who's good at math to make sure that we did get the required votes. So what that certificate, it's actually a certificate that's done by the Speaker of the House and the President of the Senate. They are actually going to certify that yes, this piece of legislation got 25 votes, 33 votes, whatever is the particular majority that you need. And once we have that certificate, we will know that that law was passed in a way that is provided for by the Constitution itself. Yeah? Other Caribbean jurisdictions have referendums. We don't have that. I think the last time we looked at the Constitution, which would have been under the Kamla Persad-Bissessar administration, that was one of the things that they had wanted to put into our Constitution. And again, if you go back to the CCJ debate, you will hear a lot of people saying we should put it to a referendum. There is no provision for that in our Constitution. You can do it, but it would not have any legal effect. Other jurisdictions, for example, the OECS, they have it. So they just had a referendum about the CCJ in Grenada, and the people of Grenada rejected the court. They were supposed to have one in Antigua as well, and I think the outcome would be the same. And delaying periods, what that is that it says that if you pass a law that amends the Constitution, it cannot come into effect immediately. You have to wait 3 months, 6 months, something like that. And that gives people the opportunity to look at the law and mount a legal challenge to it if they want to. And again, all of this is because we are supposed to make it difficult to change the provisions in the Constitution, because it is the supreme law of all of our Caribbean societies. Yeah? Everybody is with me so far? So the next set of constitutional provisions that we have, and again, not all of them you're actually going to see in the Constitution itself, but it is there because of all of the law that we've built up around the Constitution, is something called due process. So that comes up a lot when we're dealing with legislation to fight crime. So for example, when we wanted to amend the Bail Act to say people who have committed an offense with a gun, we're not going to allow them to get bail, that impacts on due process. if we ever do get the Anti-Gang Act off the ground, that will also impact on due process, because basically what due process is it is a guarantee that whatever legal process is going to be applied to you is one that's going to be fair. You can't have people being deprived of their liberty, but the way that you are depriving them of that liberty is unfair, right? And due process is supposed to ensure that that doesn't happen. It's kind of an amorphous concept, so it could mean a lot of things, or it could mean a little bit. The best definition that we've ever gotten in law is from that case called Thomas and Batiste, which, I mean, again, that is subject to a lot of interpretations, because what does an accepted standard of justice mean? That in and of itself is not particularly clear, and the reason for that is because the concept of due process itself isn't clear. So a lot of the cases that we have about to deal with the death penalty. So one of the issues that has arisen is, can you hang someone if they have a petition pending before an international body? And again, those cases throw up this disconnect between international law and domestic law. So those international bodies, yes, they can hear the petitions and they could do whatever they want, but that doesn't affect what we are doing in Trinidad and Tobago. And what the Privy Council is gradually doing is saying, yes, international law is here and domestic law is here, but I'm going to find ways to bridge that gap, right? And that's why due process might be something that would be interesting for parents of children with disabilities to think about. Because if your child has to go through some kind of process, or if, as often happens, a person with a disability has to come before the court, right? Because a lot of people with disabilities end up involved in criminal activity and so on, because they've been told all their lives they're dumb, they can't learn, they can't get to go to school, right? And a lot of them fall into probably bad company, so that when those persons with disabilities come into contact with the legal system, we have to make sure that the process that we're using for them is fair. So a simple thing like a sign language interpreter, right? Or maybe we should not just shoot them because we can't control them if they have a tantrum, which seems to be happening more and more with people with mental health problems, right? Those things violate those persons' rights to due process, because they have been deprived of their life and their liberty in a way that is inherently unfair, right? The next thing that we have is the rule of law, which again is not something that you're probably going to see in the Constitution itself, but it is a constitutional law principle. In fact, it's probably one of the most important ones, because basically what that says is that nobody is above the law. Nobody is above the law. The law is the supreme way that we should be governed, so that people can't govern in a what we call vice way, right? That's why we have the Constitution, because it sets out what you can and cannot do. And it also says that people have rights, and those rights have to be respected by persons who are in authority. So that sounds really great. We all know that, Trinidad and Tobago, and I think that's happening more now, is a pretty unfair society, and there is a widening gap between people who have and who don't have, right? And there's a lot of gray areas. Really and truly, if we follow the letter of the law, it should not be that way. So if you tell me that nobody is above the law, then you can't tell me, well, you have to treat this person this way because they are the prime minister, or this person should be able to do this because that's the president, or you can't talk to this person this way because she's an attorney at law, right? We are all equal. That's one of the things that the rule of law guarantees. But as we can tell, as with a lot of things in law, what is on the paper and what happens in reality are two different things, yeah? The next thing that you should know about is something called the Westminster model. So again, that's because when we became independent, our former colonial masters they thought that we needed help. So basically what they did is set up a government that is very, very closely modeled on the one that they have. So the UK government, the seat of their government is called the Palace of Westminster. That's why we have a constitution that is called the Westminster Model Constitution, because what that constitution does is look at the Palace of Westminster and look at how it works and writes that down on a piece of paper and says, okay, this is how Trinidad and Tobago is going to be governed. Yeah? And because we have that model, a lot of the things that we don't even have in our constitution, like certain norms from the United Kingdom, things that the Queen can do, for example, those things have been imported into our constitution as well, because they think, well, maybe we just forgot to write it down, right? But our clear intention was to have the same kind of governance structure that the UK had when we became an independent state. And then because we have that Westminster model, that's basically taking the UK government and making it a Trinidad and Tobago government, we have something called a separation of powers. And what that says is that we have a state that is organized into 3 different arms. The first one is the executive, the next one is the legislature, and the third one is the judiciary. And each of those different arms are made up of different people and different institutions, and each of those different arms have certain powers, but the powers are separate. That's why it's called the separation of powers. So there, in theory, there's not supposed to be a lot of overlap between what the executive can do and what the legislature can do, or between what the legislature can do and what the judiciary can do. And when you think about it, it kind of makes sense to set up the state like that, because the arms of government are supposed to kind of function as a check and balance against each other. So if the judiciary tries to do something that it cannot do, the legislature can step in and pass a law saying the judiciary can't do that. Or the executive can step in and the prime minister can speak to the chief justice and say, no, you're not allowed to do that. So it's good to give each of the different arms of the state power, but it's probably a good idea to keep them separate, right? Which is where we get separation of powers from. Yeah? So now that we know what are some of the foundational constitutional law principles, one of the things, and I think like this is the most important thing from an advocacy perspective, or from the perspective of people who are interested in ensuring that persons with disabilities get fighting chance or an equal share of the pie, which we all know is not happening, is the Bill of Rights. So if you look at the Constitution, and it's pretty high up in there, so it's not that easy to miss it, because it's probably like the 4th page of the Constitution itself. You will see this section, Section 4, which tells you that every person in Trinidad and Tobago has all of those rights from A to K, and those rights, they have them without any discrimination. And then it lists out what are some of the things that you're not allowed to discriminate against people with. So we have race. You can't have racial discrimination in Trinidad. You can't have discrimination based on your origin. That's where you came from, right? That's kind of obvious because all of us are immigrants or descended from immigrants, whether we want to admit it or not. Maybe somebody should tell Donald Trump. You can't discriminate against people based on color, right? You can't discriminate against people based on religion, which again makes absolute sense in Trinidad and Tobago because we are such a multicultural society. And you can't discriminate against people on the basis of their sex, right? So you have all of those rights, and you enjoy all of those rights without any discrimination whatsoever based on those characteristics that are listed in the beginning of Section 4. So this is just to give you some kind of background in terms of how that Bill of Rights came to look like that. We didn't just dream up these rights out of thin air. We actually looked at a lot of international law, which again is something that people in the disability community should be interested in, because the piece of the document that probably has the most rights for us is an international law document, the CRPD, right? So if when we were drafting the Bill of Rights, we looked at the Canadian Bill of Rights, which it in and of itself was based on an international treaty, one of the arguments we could make is that when it comes time to change that Bill of Rights or to update it, maybe we could look at another international treaty, like the CRPD, if we want to insert provisions in the Bill of Rights to give rights to people with disabilities. We won't really be, revolutionary or breaking the mold if we were to look at an international treaty, because that's where we get Section 4 from, an international treaty, yeah? And then the other thing that I want you all to remember, and that kind of feeds into what you were saying about rights and responsibilities. So no right is absolute. It can't be, because then we'll have a lot of chaos. So if I say, well, look, Section 4 gives me the right to freedom of movement, and it's carnival time, and the road make to walk on carnival day, so I just go parading all over the place. And I see somebody has a lock on their gate, and I say, no, that is obstructing my freedom of movement, so I'm going to break down that gate because I want to walk in their driveway. Or I am playing juvie and having fun, so I want to throw paint all over the place. Or I'm playing in Hearts, so I want to stand up on the person's wall in Woodbrook and Wine, so the Hearts photographer could take my picture, right? I could do that because I have freedom of movement and I want to stand on the wall, which is movement. Rights don't work like that. Right? No right is absolute. It can't be, because then we will have a society that has no order. So every right has a limitation, and some of them are inherent. So obviously the example that I gave you about freedom of movement does not mean that you could go wherever you want. So don't go and drive up by the diplomatic center, and when the army people stop you, tell them, I have freedom of movement because Miss Davidson just told me that in the court, right? That's not going to work. Another thing that limits a lot of the rights that we have is the savings law clause, because we have a lot of laws on our statute books which affect those rights in Section 4, but because they're saved, we can't do anything about it, right? That's the death penalty cases. And then another thing that limits those rights, and this is a provision that is unique, no other Caribbean country has this. It's called a Special Act of Parliament. So the Anti-Gang Act is going to be a Special Act of Parliament. Why? That act is going to be passed even though the people who are passing the law they know that what they are doing is inconsistent with the Constitution. Once they follow the formula in Section 13, they will still be able to pass the law. So once you have, in the beginning, the recital saying, this act is going to infringe the Constitution, and once they get the votes, which is why there is this to and fro between the government and the opposition, they will get to pass the Anti-Gang Act, even though the provisions in the Anti-Gang Act violate Section 4 and they violate Section 5, right? Section 5 is a provision that tells you what are the kinds of laws that you can't pass. And Section 4 is the Bill of Rights, which tells you these are the rights that you have. The interesting thing about this is that it still leaves the door open for somebody to, even though the Anti-Gang Act gets passed, to challenge it. So even though it's giving and taking away, it's giving the legislature the opportunity or the ability to pass a law that they know is going to infringe the Constitution, but it's still saying to the citizen, listen, if that law is applied to you, you can go to the court. And what can you do? Judicial review. That's the actual claim that you will be bringing, right? That's what it's called. And you will be saying to that court, this act is not reasonably justifiable, that long quotation there, in a society that has proper respect for the rights and freedoms of the individual. So that even though the government did everything they were supposed to do under Section 13 and they got all the votes that they needed, a court could still strike that act down if they think that the provisions in it cannot be justified according to democratic norms, right? And law is a lot about that as well. You give and then you take back, or you say this is a general rule, but these are all of the exceptions to it. And the good attorneys are the ones who know the exceptions better than the rule. Remember I told you about the separation of powers that we have because we model our constitution on the UK government. We have a system of governance that is very, very identical to what they have. So the separation of powers is one of the key features of their system of government. And what it says is that the best way to organize a state is to have 3 arms of the state. Each of them will be doing different things and will be populated by different people. So that is exactly what we have in Trinidad. We have 3 arms. The first one will be the executive. The next one is the legislature, and the third one is the judiciary. And each of those 3 arms are made up of different people, and they also do different things. So if you think about the executive, basically what they do is develop policy. So we're talking a lot about the national policy on persons with disabilities. That is being developed by the executive arm of the state. The next arm of the state is the legislature, and what they do is make laws. So that policy, I think, will eventually become an act. So what is going to happen is that when the executive formulates the policy that they want, it's then going to go to the legislature, and the legislature is going to make that policy into an act of parliament, and they are going to pass it so that it becomes law. And then when we have that law, and there is some provision in that law that we don't understand, or there was something that the law didn't account for, we might go to the judiciary to tell us what do these sections in this act means. And the reason that why we can go to them is because their job is not to make the law, but it's to apply it and to interpret it. So that is kind of how all of the 3 arms, even though they do different things, if they all work together, then we will end up with a good end result. Yeah? Everybody understands that? So this is, again, just to facilitate people who learn differently. So some people would not understand the 3 bullet points, but if you put it up like this, they get it automatically. So this is the 3 bullet points in the form of a chart, yeah? So the first arm of the state is the executive. And basically, because we are a republic, we have a president. So our head of state is not the queen. We only have 3 republics in the Caribbean, which would be Guyana, Dominica, and Trinidad and Tobago. Every other Caribbean island, they have a head of state, which is the Queen, and the Queen is represented by the Governor General, so they don't have presidents. We have a president, and that president is part of the executive. The president is also the commander of the armed forces, and all of these things where you see TT cons, that's actual provisions in the Constitution that provide for those things. The next group of people who constitute the executive is the cabinet. So basically what the cabinet does a lot is formulate policy. They are responsible for coming up with the kinds of policies that are going to take Trinidad and Tobago to where it is supposed to be or where they want it to go. And that cabinet is made up of the Prime Minister and all of the different ministers of government. So that's why the policy, the national policy on disabilities, that falls under the remit of the executive because that is being driven by the Ministry of Social Development and the Minister of Social Development. And I think there is a minister in the office of the Prime Minister as well who deals with children, right, and gender, right. So that's why that policy is falling under the executive arm of the state because it's being driven by ministries. And ministries and ministers all form part of the cabinet structure because you can't really expect the Prime Minister to do everything. He needs people to help him, which is where we get ministers. And even those ministers can't do everything. So we set up ministries to accomplish different things. Yeah? Everybody's with me so far? So the executive is the president and the cabinet. Now, when we talk about the president, a lot of people think, well, you know, what does Tony Carmona actually do and what is Paula May Weeks going to do other than tell us who she loves or what sex of person she is affiliated with, yeah? So the president is the head of state, so that means that any time we have to be represented in on the international sphere, if we have to interact with another head of state, it would be the president doing that, right? He's also the commander of the armed forces, so the only person that could really call out the defense force or give instructions to the defense force and to the army would be the president, right? Which is something that we have to think about because we almost had a terrorist threat, yeah, over the carnival or so we were told, right? The Constitution also tells us who could be the president, so I cannot just roll up and say, well, I am nice and I like people, so make me the president. I have to be of a certain age, I have to be a citizen of Trinidad and Tobago. I also will be the president for a specific period of time, and what I think is good is that that time doesn't coincide with elections. So that's why we have a president who was not appointed by the current administration. And when Justice Weeks takes office, she is also going to overlap with the next administration. So the 5-year term doesn't run with general elections, and that's a good thing, yeah? Another thing that a lot of people don't know is that when the president is abroad, or when he can't act, the president of the Senate becomes the president. So we were all making a big deal about the first female president, but Christine Kangaloo had acted as president way before we ever elected. Exactly, yeah? So we have had women in that role before. We just never had a woman who wasn't acting, yeah? Or who was elected, which brings us to the next slide. Or the next point, which is, well, how do you become the president? Do you go on canvass? Do you run for elections? We don't have elections. So the president is elected, but he or she is not elected by the citizens. He's elected by a body called the Electoral College. So basically what happens is that the two houses of parliament come together and all of them vote on who's going to be the next president. So if you do the math, you'll realize that that means that whoever the government wants to be the president probably will be, because they have the votes, and it's a simple majority. It's not a special majority. So whoever has the barest of majority, their candidate is probably going to succeed, which is why I think it was good that both of the parties came together for Justice Weeks, because there really was no need for both of them to work together about that. And that, to me, demonstrated a lot of maturity and where we need to be heading to. Security of tenure, basically, are those provisions that tell you, okay, you're qualified, you got elected, how can we get you out of office? Suppose it turns out we don't really like you. We don't think that you are doing what is right for the country. How do we get you out of office? Security of tenure, once you have that, it means that you can't be fired or you can't be removed from office except for specific things. So the president would have to be infirm or of unsound mind, which again is something that people who have an interest in disability should think about, what does that mean? If I am depressed or clinically depressed, Does that mean that I could be removed? If I'm clinically depressed and I'm the president, does that mean that I am of unsound mind? Or is it that I have to be schizophrenic and I can't be treated and no medication is working, right? So there are a lot of provisions in the Constitution that talk about office holders being removed because they are of unsound mind. So the same way that the president has security of tenure and there is a specific way to remove him, the same kind of provisions apply when we come to deal with the judiciary, right? Which is the last arm that we'll talk about today. The next thing that you have to know is, okay, now you are the president, what can you do? So remember, I told you that the Constitution that we have is called a Westminster model. One of the Westminster conventions or traditions is that whenever the president acts, it has to be on the advice of the cabinet. That is because, remember, the UK, they had a monarchy, and then they became democratic. So what they did is kind of split the difference so that they retain the queen, but the queen can't really do anything in and of herself. She always has to be advised that this is what she should do. And because we kind of adopted that same model of government, but we replaced the queen with the president, that's why the tradition is that whenever the president has to act, it would normally be based on somebody else's advice. There are very few areas where he can act in his own discretion. So if you look through the Constitution, you will see that there are things that the president can do in his or her own discretion. Then there are some things that they have to do after consultation. And then there are some things that they have to do in accordance with advice. And there's a difference between the three. The first one, if you say that the president can do something in his own discretion, that means that they have free choice. You can't tell them what to do, and whatever decision they make, that's it. The second one, which is about consultation, it means that the president has to come and say, okay, I'm thinking about doing this. What do you think? I'm thinking about, so one of the consultation things is the appointment of the Chief Justice. To appoint the Chief Justice, the president has to consult with the Prime Minister and the leader of the opposition. So basically the president will go out and say, I know of this attorney at law, and I think that they have the skill set that is required to lead the judiciary. What do you, Dr. Keith Rowley, think about this person? And what do you, Kamla Prasad-Bisessa, think about this person? So I have to consult, but that doesn't mean that I have to follow what they say. But I have to give them the opportunity to tell me what they think. That's what consultation is, right? And then the last one, it sounds weird, but that's how it works. The last one is where you have to act in accordance with advice. That one you have to do what you're told, right? You don't have any discretion. If you are advised to do something, you have to do it. So one of the big constitutional crises that we had was where President Robinson did not want to appoint persons who were rejected at the polls to be government senators. He really was doing something that was not provided for in the Constitution, because the Constitution says that senators are chosen. Yes, they are appointed by the president, but the president has to act in accordance with the advice of the Prime Minister. So that means that whether Mr. Robinson liked it or not, he had to follow, which is what he eventually ended up doing anyway. It just took him a while to get there, yeah? So those are kind of the three different ways that that presidential power is exercised. One of the flaws of our Constitution is that it gives the Prime Minister a lot of power. I mean, the thing is that you could look at it that way in terms of, if you are the governing party, it is highly likely that you will have the votes to make the person that you want president, right? So if you were the Prime Minister and you and I went to school together, and you really like me, and you think I'm qualified, you could make me the president because you will get all of these people in your party to vote for me at the Electoral College. But, and this is what I think people don't understand enough, once you elect me, it's very difficult for you to get rid of me. So that means that, okay, yes, you have allowed me or you have created the way for me to get this job, but once I'm there, it is very, very difficult for you to interfere with me if you don't like what I'm doing. We don't look at it that way because we say, well, Keith Rowley wants this person to be the president, so she's going to do whatever he says. No, it doesn't work like that, or it shouldn't work like that. But I think that is the reality that we are faced with. Just because you give me a position doesn't mean I'm your puppet, right? And especially where there are things that I could do in my own discretion, one of which is appointing independent senators. The Prime Minister has no input into who the President chooses to be those independent senators. So there are little provisions, if you know them, you could exploit them, right? Which is why sessions like these are important, so that people know that these things exist. Yeah? Another thing is that presidents have a lot of protection in terms of the decisions that they make. So not every kind of presidential decision could be reviewed by a court of law. One of the things that prevents that is called an ouster clause. So basically what that says is that if I make this particular kind of decision, if I make a decision where I'm acting on somebody else's advice, and you think that I've made the wrong decision, you can't take the president to court. Which I can understand, because once the president is acting on advice, he doesn't have a discretion. So it's kind of unfair now to turn around and try to sue him or her for doing something that he didn't have the option to refuse to do. Yeah, so that's called an ouster clause. The other thing is that the president has immunity from being sued if he does things in his official capacity. So appointing persons to service commissions, appointing senators, appointing ministers, all of those things are official, even appointing the Prime Minister. That is done by the president. A lot of people think, well, Keith Rowley won the election, so he's the Prime Minister. No, until the president administers that oath of office and gives him the instrument of appointment, he is not the Prime Minister. He is Dr. Keith Rowley, who just won the general election, right? So once the president does actions in his or her official capacity, you can't sue them. Courts are starting to chip away at this, though, because do you all think that, what do you all think about that? Do you think that it's hard to reconcile immunity and ouster clauses with other provisions of the Constitution, or do you think they all work together, based on what we did before?
The president could make a decision that could infringe on the Bill of Rights. Mm-hmm. So there's a bit of, in my mind, a bit of a potential conflict there.
Yes, and remember one of the fundamental principles of constitutional law is the rule of law. And the first principle of the rule of law is that nobody is above the law. So how could you create a constitution, say it is supreme, say that that constitution abides by the rule of law, and then create an exception for this one person to not be answerable to anybody, right? So that's why now a lot of courts have started to say, okay, you know, we know that there is an ouster clause and we know that there is immunity, but we're going to find a little loophole, which is what attorneys do, right? So those three cases at the bottom are all examples of people who took the president to court. The only reason you see the word AG, which means Attorney General, is that that's how you have to frame the suit. Anytime you sue in the state, you have to put the Attorney General. But really, the person or the persons whose actions they were challenging was the president. And in Nizam Mohammed, he won. The other cases, what they did is say that presidential immunity and ouster clauses are not absolute. So there are situations where even if we have an ouster clause or we have presidential immunity, a court can look at what the president has done. So Devant Maraj and Gladys Gafoor, because those cases said that, they opened the door for Nizam Mohammed, which is where he got removed from the Police Service Commission when he said there weren't enough East Indian people in the police service. Right, so he successfully sued the president because the president dismissed him but didn't give him a chance to plead his case. And that is looked at as being inherently unfair. I think it was George Maxwell Richards. I believe so. I'm not sure though. I think so. Right, but I mean, it was kind of a hollow victory because all he got was a declaration. He didn't get his job back. Because who would want to go back to a job that nobody wants you to have, right? So all he got was a declaration that what the president did was unconstitutional. But the important thing is that he won, which gives us a way of knowing that, listen, yes, we have this president who is very powerful, but nobody is above the law. Yeah? Yes. Yeah. So one of the other things that the president does, and again, this is one of the powers that we don't know that they have, is the concept of presidential assent. Act of Parliament does not have any legal effect until the president assents to it. Yeah? So that's why I think when the Child Marriage Act came into force, somebody was arrested in El Socorro because they had gotten married to a 16-year-old, and their attorney was able to successfully get them released from custody. The reason for that is that even though the act was passed in the parliament, the president hadn't assented to it yet, and it's the assent that gives that act legal force. So until the president assents, that act is an act of parliament. Yes, it has been passed, but it doesn't have legal effect. And this is not something that is unique to Trinidad and Tobago. A lot of other constitutions have it as well. Because of the way that our clause is worded, and because of that or, there is a lot of debate in Caribbean constitutional law about whether the president could refuse the assent. So if you read that section through, what it says is that when the bill, which is the act that's passed by the parliament, when it is presented to the president will either signify his, and that should be her now, assent, or that he withholds assent. So the fact that we have that or creates this question of, well, when could he get to withhold, right? A lot of people think that that or doesn't mean anything. So there is no ability for a president to veto legislation, which would mean that they are saying, I'm not assenting, even though that's what the section clearly means. I think the reason why those two gentlemen think that is because of that Westminster Convention. So remember, I told you that this is a general rule. The president really doesn't do anything on his own. He always has to act on somebody else's advice. So they are saying that when you read that general rule and you put it together with 61(2), what that means is that he could only withhold assent if he's told to do so. Other people say no, the provision is clearly drafted. There is no room for debate. The thing says or, and that's what it means, right? What do you all think about that? Do you think there are any problems with a president saying I'm not? So suppose we do get the national policy and we advocate and we get disability legislation. and we get it passed by the parliament, and then it gets to the president. So if it were a piece of legislation that said that if somebody were to pass a piece of legislation saying they don't like the color pink, so anybody who wears the color pink, has a pink handbag, a pink pencil case, pink phone case, they are going to be imprisoned for life. And that act is actually passed. And I've seen a lot of people with pink, right? I have the pink pencil case and phone case, right? So a lot of people like pink in the room. If we get that act passed, we might want the president to say, no, that act doesn't make sense and you can't outlaw the color pink. And there are people who might be colorblind and don't even know that this is red and not pink. So the act can't work. So I'm saying that the veto power, it's a good and a bad thing depending on how you look at it. But I just want you to know that it exists, because I think a lot of people think we have a president that doesn't do anything. And the reason why we think that is because we don't know. This is 61. You know, most people don't read beyond Section 5 of the Constitution. Nobody is going down to 61 and 80 to see what is down in the end there. Yeah? The other thing is about states of emergency. The only way we could have a state of emergency is if the president issues a proclamation. And the president could only issue that proclamation if he or she is satisfied that certain things exist. So we can't have a state of emergency because somebody doesn't like the color pink, right? We have to have a state of emergency because there's impending war, or there's a natural disaster, or there is some kind of action that's going to threaten public life or threaten public access to services that are essential to life. And the president has to actually look at the documents that are presented to him to see if it fits into one of those categories. Only if it does, then a proclamation is going to be issued. And again, I think, you know, these things sound really good, but we have to know this stuff because we almost had, allegedly, some kind of terrorist threat over the carnival, and I don't think that would be the end of it. You know, we live in a different world. Everybody is good with that? Because remember, I told you the executive is made up of two bodies, or two functionaries. So one is the president, the other one is the cabinet. So basically what the cabinet is the prime minister and all of the government ministers. If you look at the wording of the Constitution, it is possible to have a cabinet of just two people. The prime minister and the attorney general are the only people who are specifically mentioned as that those people have to exist or be appointed in order to have a cabinet, right? But nobody expects Dr. Rowley or Faris Al-Rawi to run Trinidad and Tobago. So that's why we have all of these different government ministries. There is no limit on how many ministries you could have. So that's why under the Kamla Prasad-Bissessa administration, we had a lot of ministries because I think she was probably more focused on specializing, you know. But under this administration, we have a lot less because they want to consolidate and save money, right? Because ministries, the more ministries you have is the more money you have to spend. So the prime minister obviously is the head of that cabinet. The prime minister is appointed by the president, which again, the fact that you win the election does not make you prime minister. You become the prime minister when you are appointed by the president. Winning the election helps because the president could only appoint the person who commands the support of the majority of parliamentarians, right? So if you win the election, that's the only way you will satisfy that criteria. That's when he gets to choose. So if the prime minister becomes ill and can't function, then the president has a discretion, which means that he doesn't have to follow what anybody else tells him, which is what happened with the 1818, right? So it's not true to say that we have a president that can't do anything. They can, right? The other person that you have to have in the cabinet is the Attorney General for obvious reasons. You need somebody with a legal background to tell you you can't really do that or you could do this, right? So basically what the Attorney General is, his primary responsibility is really to advise the government, but he's also, he's responsible for the general legal affairs of the country as well. And then you have, again, because we can't expect two people to shoulder the workload, you have all of these different government ministers, right? There's a lot of debate about whether we appoint the right people or whether we should have fixed ministries, whether the Minister of Health should be a doctor, the Minister of Education an educator, right? The reasons why we have those debates is that the Constitution doesn't say. It doesn't say how many ministries you have to have, and it doesn't say how you become a minister. All it says is that in order to be a minister, you either have to be elected or you have to be a senator. It doesn't say if you want to be the Minister of Social Development, you should have a degree in social work, right? And there's a lot of debate about whether we should say that or not. Yeah? What I want to finish up is the legislative process. So remember, I told you we have three arms of government. One is the executive and one is the legislature. The last one is the judiciary, but all of them work together. And this is how it happens. Basically, the executive is going to come up with the policy, but to make that policy an act, they have to bring the policy. The executive, will come up with the policy, but to make that policy an act, they have to get the legislative arm of the state involved. So obviously all of us know where the Red House is, or used to be. I pass every day, so it's going to be there just now because they're doing a lot of work on it. And basically that is where our parliament sits. The Hyatt is a temporary thing. And we have what is called a bicameral legislature. And again, the reason that we have that is because we copied from the Palace of Westminster. That's what they have, so that's what we have. So we have two houses of parliament. One is called the House of Representatives, which is made up of all of the people that we elect to be there. And we have 41 seats. Teresina, the reason for that is because nobody wants to go back to an 1818 tie. So we changed that provision of the Constitution to move it up from 36 to 41, which is a nice uneven number. So 1818 will never happen again, right? And in order for you to become an MP, you have to be over the age of 18 and you have to reside in Trinidad for 2 years before you seek election, right? Because that, I think there were debates about dual citizenship, right? None of that is in the Constitution. All it says is that you have to be a resident here and you have to be 18 years and older. The Senate, which is, so the House of Representatives is sometimes called the lower house. The Senate is called the upper house, and everybody in the Senate is appointed, so none of the senators are elected. And that's why President Robinson had a problem with people who were rejected at elections becoming senators, because he felt like that was kind of a roundabout way of getting them into the parliament, right? So the theory is that in order for you to become a senator, you have to be appointed. You shouldn't be somebody who ran for elections but lost. So again and again, if you do the numbers game, you will see that the government has a majority in the Senate. So out of the 31, they have 16. And everybody else is either an opposition senator or an independent senator, which is unique to Trinidad and Tobago. No other constitution has that. Senators who are appointed by the president in his or her own discretion. And the president gets to choose 9 of those people. And sometimes when it comes time to vote on acts that require special majorities, you will see how it is a good thing to have those independent voices there, because they don't toe party lines and they also make pretty valuable contributions because a lot of them tend to be professionals or people who've done a lot of work in the community. And I think that that's a really good thing. Maybe more constitutions should have independent senators, but we are the only constitution in the Caribbean that does, right? Guyana is unique because that's the only legislative house that is one body called the National Assembly, and they get elected based on proportional representation. So whenever you hear people talking about that's where we should be going, they're modeling that argument based on what happens in Guyana right now. So you could win the election but not end up with a lot of power because you have to contend with all of the persons in the National Assembly to get anything done, which I think is what is happening to David Green John Day right now. They want to do stuff, but they don't have the votes. All senators and ministers are appointed by the president. The ministers are appointed by the president, acting in accordance with the advice of the prime minister. For the government senators, they are appointed by the president, acting in accordance with the advice of the prime minister. The opposition senators, appointed by the president, acting in accordance with the advice of the leader of the opposition. And then the president gets to choose 9 other people. And those 2 houses make up the legislative arm of the state. So whenever you bring laws to be passed, they have to be passed in the House of Representatives and they have to be passed in the Senate. And depending on what kind of law it is, you have to get a particular amount of votes out of the 41 or out of the 31 in the Senate. You might run for election and win your seat, but your party doesn't win enough seats to form the government. So in the House of Representatives and in the Senate, you have people who are in government and people who are in opposition, which is good because then they have to work together, which is what they should be doing. So once you run for elections under whatever party ticket and you win, you will become a member of the House of Representatives. And that's why we refer to them as MPs. Members of Parliament. If you are asked to serve by either the government or the opposition or the senator, but you didn't run for elections, then the only place you could be asked to serve is in the Senate, because everybody there would be appointed and not elected. So if you want to know why we have law, it's actually written in the Constitution. So the ability of Parliament to make laws is not some made-up thing. We have it written in black and white. They're not supposed to make whatever laws they want, though. They have to make laws that foster peace, order, and good government, which is kind of hilarious because a lot of people debate whether they do that or not, or whether they just serve themselves. And the other thing to remember is that they can't make any law that's going to violate Section 5 of the Constitution. So Section 5 has a whole list of things that no parliament could pass a law to do. And a lot of it has to do with when people are detained, like you can't take away the right to instruct an attorney, you can't take away their right to be brought before a court, you can't take away their right to get access to bail, right? Which is why things like the Anti-Gang Act requires a special majority because those acts are trying to whittle away at Section 5. Yeah? This is just an overview about why we have law, and I thought that I should mention it because one of the things that I think a lot of people in this room probably want is disability law, right? So if law is supposed to do all of these things on the board, then we should already have disability legislation, right? Especially the last one. If law is supposed to reflect our culture and reflect changing circumstances, then we should already have disability law on our books. It shouldn't be something that we have to now be fighting up and trying to advocate to get, yeah? So again, there is this disconnect between what law is supposed to do or what law says and what people's lived realities are. And I think that happens anywhere. It's not something that is unique to Trinidad and Tobago. Okay? The next thing that I think you all need to know is how, okay, so we have this policy. Somebody is going to sit down and look at the policy and draft it and make it into a piece of legislation. What is going to happen for those words to become law? So obviously, because it's something legal, you know there has to be a process, and the process has to have rules about what can and cannot be done. So this is just to give you an introduction into what happens in order to make something an act of parliament. So the first thing you have to do is lay what is called a bill. So before the president assents to a piece of legislation, it's always called a bill. It's the president's assent that makes it an act. And because it is an act, that's what gives it legal effect. So all before then, it's referred to as a bill. And basically what happens is that that bill, which is going to come from some government ministry, is going to be brought to the parliament and presented to either one of the houses, either the House of Representatives or the Senate, right? So you could choose either route, but you have to have the bill debated in both houses. Everybody follows that? So let's use the example of the disability policy. So the disability policy is being driven by the Ministry of Social Development. The Ministry of Social Development is then going to liaise with the Attorney General to get that policy into the form of legislation, because legislation is worded a particular way, right? The Attorney General is then going to take that legislation that has been drafted, which is called a bill, and carry it to the Parliament. And at one of the sessions of either the Senate or the House, he's going to have it on the order paper. So the Speaker is going to announce to everybody there, we are presenting this bill in order for the House or the Senate to debate it and eventually make it into law. Because you could have a perfect policy, all of you all come together, who like and don't like, we put that aside, all of us come together and our collective wisdom draft this wonderful policy, and it could stay there until I reach 150, right? Because nobody would have ever told you all that, listen, in order for you to get that policy to become an act of parliament, you need the involvement of first the executive, right? Because cabinet has to now approve that policy. That approval by cabinet is what allows the Ministry of the Attorney General to start to draft laws, and then the minister or the Attorney General himself is going to take that down to the Hyatt or the Red House and start the ball moving by laying it in the House or in the Senate. Whenever a government comes into power, there is a list of ministries that is published, and it tells you what the ministry is responsible for. There's a particular name for that document. I will find out overnight and I'll tell you tomorrow, because that document is going to tell you which ministry has responsibility for disability, and based on this listing, it is social development. Disability is a cross-cutting issue, right? So if you look at the CRPD, you'll see that I'm talking about health, education, somebody is talking to me about transport, housing, right? So it depends on what it is you're trying to get accomplished. If all you are trying to do, which is drawing on what you said before, you have to creep before you could walk. If all you are trying to do is get education changed, it might be good for you to not only approach social development, right? So you're following the protocol, they can't tell you that, you're breaching protocol, but also to approach somebody in the Ministry of Education, because those two people now have to work together to come up with some kind of legislation that's going to improve or provide for what the CRPD says about disability. And if you look at the CRPD itself, one of the things that it talks about and it requires the state to do is actually set up a national body with all of these different specialties to develop policies for persons with disabilities. I don't know if we have that. You know, it was promised, yeah, and I've been hearing things here and there, but we should know. That's my thing. I shouldn't have to depend on, oh, I have a friend working here who told me this and that, right? Which is how Trinidad works. And that's another thing as an advocate you have to be aware of. You know, you have to work with what you have. And you have to know the system that you're working with. And all laws start as government policies, which means that you have to have somebody in the government. Now, what senators could do is raise the issue, so they could ask for a motion to be tabled about the plight of persons with disabilities in Trinidad and Tobago, and we could have a lot of debate about that, but it might not result in some concrete piece of legislation. But that is also a good way, because remember, advocacy has to be multi-pronged. You can't put all your effort into doing one thing. You have to approach it more holistically. We don't have orders in council anymore, because that's how we used to pass laws under colonial authorities. Now we have acts of parliament. Another thing that we have is a lot of delegated legislation. So I was talking to somebody about transportation policy. One of the things that the government may try to do is say, well, we already have a Transportation Act, let us just make some kind of rules or regulations to make that act effective. That's going to be delegated legislation. That kind of legislation doesn't go through the same lay-in, debate, assent. It's quicker and it's easier, but it's only reserved for things that are really technical. So for example, we have a Telecommunications Act, and one of the regulations under it talks about things like bandwidth and what kind of devices you could use. Those are things that require specialized knowledge. So what they did is just pass the act and say, look, later on we'll get the technocrats to figure out the regulations. But as people in the community, you have to know that regulations exist, because what regulations do is kind of give the act more teeth, or if there is some kind of specialized knowledge that is needed to make the act operational, they will probably put it in a regulation rather than in the act itself. The last thing that I wanted us to do before we break for lunch is just to look at this, which basically tells you, yes, there are laws, but some laws are more important than others, right? Which is just like Animal Farm, some are more equal than others. So obviously we know, based on everything that we've talked about for the day, that the Constitution has to be on top. The next rung would be legislation, or something called the common law. So basically the common law is to deal with situations that legislation doesn't cover. So there are certain rules that have been devised by judges over hundreds and hundreds and hundreds of years, but they are not in any act of parliament, but they're still part of the legal system that we have. The bottom rung, and as you go down the hierarchy, the binding effect of that law becomes less and less, right? So the Constitution obviously has the most authority. The next rung, which is legislation and common law, has the second most authority. And then the one with the least authority, right? And the one on this side of the hierarchy, which is what we should be most passionate about, because all of us know about the CRPD. That is on the bottom, right? Because it's part of international law. So what we have to figure out is a way to get it out of that bottom rung into the second, or maybe even the first, right? But if you don't know that this is the hierarchy that we have, you will constantly be asking yourself, I'm going to all of these workshops about the CRPD, and when I hear all these things that my kids are supposed to have, I'm so mad, because then when I go to the school, or I go to the health center, or I go for therapy, it's something different. This is why you're having that experience, and this is what we have to fight to change. But you can't fight to change it if you don't know why it is the way that it is. Yeah? So the Supreme Court of Trinidad and Tobago is made up of the High Court and the Court of Appeal. The High Court is where you would go once you have to bring any kind of civil or constitutional claim. And then if you are unsatisfied with that decision, you get to appeal it to the Court of Appeal, right? And then the last court that we have, which is a court that most people interact with the most, especially if you're doing things like maintenance, if you ever have to pay a traffic ticket, right, which I'm sure everybody had to do because they're really enforcing traffic laws, you would have had to interact with the magistrates' courts. And with the magistrates' court, they are not in the whole of justice, right? Rather, we have magistrates' courts throughout Trinidad and Tobago. So we have 13 different magisterial districts, and for each district, there's a magistrates' court there. So that's why you will see the Tunapuna Magistrates' Court, or the Shogunas Magistrates' Court, or the Scarborough Magistrates Court. So each different magisterial district has a magistrate. And the other thing that I have up on the slide is just to give you an idea of how many judges work for each of these different judicial bodies. So we have 12 people sitting at the top. Not all 12 of them would hear one case, so they divide the caseload among the 12 of them, right? But obviously you want an uneven number so that the judges, if they have to vote, they would have somebody who would break a tie if there is one, right? With the Supreme Court, we have the Chief Justice, and then he has 13 Court of Appeal judges and 35 High Court judges. And then with the magistrates now, they have the most judicial officers, which kind of is obvious because they have the most courts throughout the entire country. So we have the chief magistrate, you have a deputy chief magistrate, you have 13 senior magistrates and 42 magistrates who serve in all of those different 13 magisterial districts. Yeah? So they deal with the most cases, and they also have the most judicial officers assigned to those courts. So if you were to take the slide before and put it in the form of a chart, again, to facilitate people who learn differently, this is what it would look like. You would have the Privy Council at the top, then you'd have the Supreme Court, and we know that in the Supreme Court there are two different courts, the High Court and the Court of Appeal. Then at the bottom, you'll have the magistrates' courts. And the reason why I put the specialized courts up there is because of the Equal Opportunity Act, which I'm sure a lot of you all know about, because that is one of the few pieces of legislation that we have dealing with disability. They are an example of a specialized court. So they only deal with cases that arise out of the Equal Opportunity Act. They don't deal with any other kinds of cases. In a similar way, the industrial courts, they only deal with industrial relations disputes, and the Environmental Commission only deals with appeals from decisions of the EMA. Yeah? So those are like specialized judicial bodies, but they are still part of the judicial structure. So now that we know what the court system is about, the key to understanding judging and how judges function is a concept called judicial independence. So the picture there, which is not coming out good, I think it's because of the white background. That picture there is actually a statue called Lady Justice. And if you look at the symbols that she has, you'll understand judicial independence, because in her hand, she has a sword, and that's supposed to represent punishment. So one of the things that judges can do is punish people, obviously, by either sending them to prison or making them pay a fine or making them apologize. She also has scales in her hands, and what that means is that judges are supposed to be objective. They're supposed to listen to both sides of a case and make the best decision. They're not supposed to favor one side over the other. And then the third thing that you will see is that she is wearing a blindfold. And the reason for that, again, is because she has to be objective and impartial. So a judge is not supposed to take sides, and the way that that is represented in this figure is to actually make her blind, which I think is interesting from a disability perspective, you know, to the idea that if you take away somebody's sight, they would probably be fairer than someone who can see everything, yeah? So if you remember those three things, the blindfold, the scales, and the sword, you know more about judicial independence than the average person. Those three things, which is objectivity, being fair, and dispensing punishment, then feed into these different elements of judicial independence, which has been, these are principles that have developed over time, and there are a lot of international law documents that spell out how judges should and should not behave. So one of the elements of judicial independence is that you have to have a transparent process to appoint judges. So in all of the conversations that we've been having about the judiciary and the upheaval that we're having with the Chief Justice, one of the things that has come out of that conversation is for us to look at how do you become a judge? Can you just roll up and say, I want to be a judge? Do you have to be friends with this person? Can you apply? Are the positions advertised? All of that is part and parcel of judicial independence, because the way that judges are appointed is part of judicial independence. So if we were to look at our Constitution, it spells out how our judges are appointed. The Chief Justice is appointed by the President, I told you that before, and the President has to consult with the Prime Minister and the Leader of the Opposition. All of the other judges are appointed by a body called the JLSC. So that is an acronym for the Judicial and Legal Service Commission. That is one, just like the Public Service Commission, Police Service Commission, Teaching Service Commission. That is an independent body that is created by the Constitution itself. And the reason why we want to have those kind of independent bodies appointing judges is because we want to make sure that judges themselves are independent. So if you appoint judges in a way that is transparent and fair, then you will get judges who themselves are transparent and fair. You won't have a situation where the judges are carrying out the will of politicians, because a large part of what judges do evaluate actions of either the executive or the legislature, and that's why we want them to be as independent as possible, yeah? The next element of judicial independence is security of tenure. So remember, I told you there's a lot of overlap between the president and judges. All of that is because we want to make sure that the president and judges are independent and impartial. So when you do become a judge, which is what is happening right now, the debate that we're having about whether we should continue to have Chief Justice Archie as our Chief Justice. Once you become a judge or once you become the Chief Justice, you have security of tenure. So what that means is that your office cannot be taken away from you very easily. You also have a mandatory retirement age, so even though you have this job, you're going to have it for a fixed period of time because you have to retire when you get to the age of 65. But once you are a judge, you can only be removed for certain reasons, just like the president, because of misbehavior, because you have of unsound mind, they have an infirmity of the mind, and again, because we have an interest in disability, we have to think about what do those things mean, you know, is it clinical depression or should it be something more severe? Are we setting up a constitutional system that makes it hard for a judge or a person with a disability to become a judge? Because you probably won't apply for the job if you know that one of the ways you could be removed from office is for somebody to raise your mental health problems, for example, yeah? And the other thing is that even if you do satisfy one of the grounds to be removed, you have to go through a particular process, which is what we are debating right now. is the process that we're using in relation to some of the allegations that have been made about the Chief Justice. Is that how you are supposed to remove a judge? And one of the most famous constitutional law cases in the Caribbean came out of an attempt by a Chief Justice to remove a judge, right? The name of the case is Rees and Crane. And that case tells you very clearly, this is the process that you have to follow to remove a judge. And if you don't do it, then a court is not going to allow that judge to be removed from office, regardless of whether you think they should be a judge or not. So the process is very strictly applied. Yeah? The next thing that we look at is when you're thinking about judicial independence, you could think not just about the process in terms of how do you become a judge or how are you removed from being a judge, but what are the mechanisms in place to make sure that while you're a judge, you function independently. So one of the things we obviously have to think about is who pays judges. Where does the judiciary get money from? Who pays the salary of the Chief Justice? We don't have any Caribbean judiciary that is funded independently. All Caribbean judiciaries are funded by the executive arm of the state, so that there is actually a provision in the budget saying that for this fiscal year, the judiciary is going to get so much money, and so on and so forth, right? So every time we pass a budget, there is a line item in there for the expenses of the judiciary. The only judicial body that has been able to break that mold is the CCJ, which I find is ironic because we always think they are not going to be independent, but they are probably one of the most independent courts that we have in the Caribbean because they have a trust fund. So they don't have to depend on the government for money. They have their own money set aside, and the fund is managed by a board of persons who, again, are independent. That is not what happens for any other judiciary in the Caribbean. And in addition to thinking about where the money comes from, another part, because that money will mostly cover administrative expenses. So the next thing you have to think about is salaries. Who pays them? Where does that money come from? Can we say, well, we're going through tough economic times, so judges will have to get paid less? That can't happen. The Constitution protects judges from those kinds of things. So they will continue to be paid the same amount regardless of whether oil runs out or not. And those salaries are charged on the consolidated fund, which means that there is a built-in pool of funds that is available to pay those salaries regardless of what the national budget is or what the deficit is. Because right now we are in a deficit. We don't have enough money to pay for all the expenses that we have. But judges are taken care of, and the reason for that is because we want to make sure that it is unlikely for somebody to come and say, here is a suitcase with $1 million. I have a case before you tomorrow, and if you decide the case in my favor, you could have the $1 million, right? Because the judge is already taken care of because his salary is guaranteed and it can't be interfered with easily. With independence comes accountability, right? Because remember, one of the tenets of the rule of law, nobody is above the law. So we can't have these people and make them so independent and untouchable without making some kind of provision to hold them accountable when they do misbehave. So if they were to take the $1 million bribe, what can we do about it? That's where accountability comes in. Most of the principles for accountability are actually in a code of conduct, which all judges are supposed to ascribe to. And another thing that we do to kind of protect them is to say, just like the president, if you are acting in your official capacity, you cannot be sued. Because what we don't want is for a judge to decide a dispute between two persons, and then the person who loses turns around and turns around and tries to sue the judge. So once the judge is acting in his official capacity, then the judge is protected. We could criticize judges too. That's another way of kind of holding them accountable, and that's probably why for the Sunday Express for, about 2 months, every story is about the judiciary, right? And even today's Express is the same thing. And one of the reasons for that is that you are allowed to criticize judges once the criticism is legitimate, which I suppose most people think the criticism of the Chief Justice is. Whether it is or not, we could talk about that all day, I suppose, right? And then the last thing that you all have to know about the judiciary, and which feeds again into your advocacy, because somebody was talking about precedent. I think it was Teresina when I mentioned the Ria Mohammed case. This is why she mentioned that. So because law is supposed to be predictable, and because law really involves applying rules or applying exceptions to rules, we have this principle called judicial precedent. And what that means is that if I decided a case 10 years ago that is similar to the case that I have to decide today, I could take that case from 10 years ago and apply it to the case that I'm deciding today. And it makes sense because what you don't want is for one judge to decide the case this way, and the other judge to do it this way, and the third judge to do it that way, and the fourth judge to do it that way, because then it creates a lot of confusion about what is the state of the law, what is the legal rule, because I will have 4 different rules in each one of those cases. So the doctrine of judicial precedent accounts for that. It says that you are to treat like alike and unlike unlike, right? So once you have a case that is similar in facts and circumstances, the way that that case has been decided should be the way that it will be decided for time immemorial, unless you could show me that circumstances have changed or that that case was wrongly decided, yeah? So it depends on what kind of case it is, and the law will tell you what is the court that you're supposed to go to. So if the law says for traffic offenses, you have to go to the magistrate's court. For a maintenance order, you have to go to the magistrate's court. If you are charged with a criminal offense, but it's not a serious one, so it's like, I'm trying to think of a criminal offense that is not serious. If it is a minor offense, like
robbery,
you broke down somebody's gate because you're trying to exercise your right to freedom of movement, right, which is malicious damage to property, you will probably have to go to the magistrate's court. If it is a serious criminal offense like murder, you'll have to go to the high court. So you'll be on the second level, which is the Supreme Court. If you want to challenge anything in the Constitution, you have to go to the High Court. Section 14 of the Constitution tells you that. So a big part of being a lawyer is learning the law and knowing where you are supposed to go, or where your client should bring their case, which is the best court to do that.
so in the case of disabilities, if anything has to be, if any hearing has to take place, it will have to be in the specialized courts?
Well, no, because the Equal Opportunity Commission only deals with appeals from dealing with the Equal Opportunity Act. So if your disability case is about the Equal Opportunity Act, you will be going to the Equal Opportunity Commission. If your case is about Section 4F of the Constitution, which is what we were talking about before, you will have to go to the High Court, because Section 14 of the Constitution says whenever you're bringing an action under Section 4, you have to go to the High Court. If the High Court doesn't decide in your favor, then you go to the Court of Appeal. If the Court of Appeal doesn't decide in your favor, then you go to the Privy Council. And once whatever the Privy Council tells you, that's it. You are stuck with that. And that case becomes judicial precedent. so that all the other courts have to apply the law the way that the Privy Council says it is supposed to be applied.
I wanted to ask, what is the role of the ombudsman? And is that still in effect? I mean,
Yeah, it is, and I think a lot of people don't use it. I don't know that I would describe it as being a court. It's more a dispute resolution mechanism. So you can go to the ombudsman, and there's a banking ombudsman, which a lot of people don't know about as well, because we complain about bank fees and long lines, right? There's a banking ombudsman, and what those bodies do is basically take complaints from members of the public and try to have them resolved by approaching the institutions themselves rather than having you, member of the public with no power, do it. The only thing is that they can't make binding decisions, so they could recommend that, the bank should do this, or the public institution should do that, but they don't have a lot of teeth. And that's why a lot of people, I think, don't go to them, in addition to the fact that people don't know they exist. The other thing that you all should know about litigation is that litigation is for, the strong of hearts, and it costs a lot of money, right? And I think one of the reasons why it costs a lot of money is because it takes years for a case to go through the system, right? So if you file your case today, you'll probably get a trial date maybe for next year if you're lucky, because there are so many cases waiting to be decided, and there are only 35 judges in the High Court dealing with the whole of Trinidad and Tobago. Yeah? And the higher you go is the more money you'll have to spend, of course, because when you get to the Privy Council, you have to get British attorneys to present the case for you. One of the things that law has developed is to say that you are entitled to a process that is fair, not one that is perfect. Right? And when you think about it, it makes sense, because life is not perfect and the world is not perfect. But all we could try to do is make the process that you have to go through as fair as possible.